It's been a while. And so, yes. Oh, I should. All right, I'll hold it a little closer. Maybe that's better. Um, so, yeah, I've worked for the Bureau of Reclamation for 4 years. I worked with Jim and Jennifer and Jonathan and Mike, and I think I saw Sharon over there. So it's good to be here. I also work with Mickey and a bunch of other folks. I kind of see the collaborative program was like in three different stages, and I feel like I was maybe in the second stage. And you guys are now on a great new stage with West, and it seems like the collaborative program is doing quite well from what I have gathered. So here's a slide. This is me in my full sort of COVID beard mode. And this is me, obviously, trying to balance myself and my need for fun with my need to breathe and stay afloat. So, and so I know a lot of you, for a lot of you, this will probably be review. And some of you probably have a deeper knowledge and understanding of these topics than I do. But this presentation aims to kind of give just an overall perspective of the various competing authorities and laws that govern the Rio Grande. So, as you all know, it's a highly managed system that humans have significantly altered through river channelization. That would be the Bureau of Reclamation and the Army Corps of Engineers, and the construction of storage reservoirs, both agencies, and the MRGCD, diversion dams, canals, and drains. And then the river managers of this system, they have come from federal, tribal, state, and local governments, and they each have different jurisdictional authorities. And so, at the end, I'll show you John Wesley Powell's proposed map of the West based on watersheds, and this would be a hell of a lot easier to do what you all are trying to do if Congress had only listened to John Wesley Powell. So we also have these overlapping federal, international, interstate, and state laws. And so figuring out how you're going to meet the needs of the species, considering climate change impacts that are projected, you got to navigate through all these different laws, and you need to understand them. So these are the players. And I think this may be a duplicate side, so we'll look at this slide. So just to give you a sense of how many entities are involved here, there's a lot of them. And just from the Fed side, you can see we've got three different departments here, and the Department of Interior represented mostly, and it's all sort of broken down. And then, in addition to who you might think of as Fish and Wildlife, BOR, and BIA from Interior, you also have the Solicitor's Office, who is advising all of the interior agencies, which is where I worked for a while. You have national parks, Bandelier National Park, and you have USGS that does a bunch of work. And then, of course, Department of Defense is the Corps, and the Department of Justice defends all of these departments and agencies in litigation, which we, as you all know, we are now facing again with Wild Earth Guardian's recently filed lawsuit. There's 6 pueblos. We have the country of Mexico to the south. We have 2 very thirsty states bordering us. And then from New Mexico, there's a whole bunch of different agencies. We've got the State Engineer's Office, Interstate Stream Commission, Game and Fish, and then the Attorney General, who represents the state in litigation matters. And then the big water player in the valley, MRGCD, the Water Utility Authority. We have the City of Albuquerque, and then other signatories to the collaborative program. And then I threw in Wild Earth Guardians here. Of course, we've got the NGOs that are paying attention to all of this and trying to keep everybody in compliance. Let's see. All right, so thought I'd start with a picture of the basin here, or map of the basin. You can see that, headwaters in Colorado, and stuff that you all already know, dumps out in the Gulf of Mexico, is the border between the United States and Mexico for a while in Texas. And so here, this is from Reclamation's BA. This is the plumbing of the system. And so we're gonna go through each one of the projects in each one of the reservoirs to just talk a little bit about their authorization, because that all really comes into play a lot when you're thinking about what you can and cannot accomplish um, with regard to meeting the needs of the species. So we'll start, we're going to go from north to south. We've got the San Juan Chama project, which is a trans-mountain diversion that takes New Mexico's apportionment of the Colorado River and brings it to the Rio Grande Basin through a series of tunnels. And we've got here, this is a bunch of the contractors. I think this might be from the BAA, I forget. But anyways, gives you a sense. The total yield is, a full, if there's a full allocation, is almost 100,000 acre feet, half of which goes to the Water Utility Authority, a third of which goes to the district, and then the remaining is split up, a lot of it going to tribes to settle their water claims. There's a little photo of Heron. So now we're at Heron Dam, which is where San Juan Chama water is stored. It's really the only type of water that can be stored there. And so you'll see with each one of these reservoirs, there's limitations as to what water can be stored there, what the uses are. So Heron really is just for San Juan Chama water. And so as we go through this and you see the different authorities, there's a little example of what happened earlier this year, I think it was, when which kind of goes to show the challenge, the difficulty of trying to do something novel in the system. So as I think you all know, El Vado is under construction. It is being constructed. And so Reclamation, BIA, and the Pueblos needed to find another place to put the PMP water, which we'll talk about in a second. And so it was like, all right, well, where are we going to put that water? Well, can you put it in Heron? Well, there's a lot of people that said maybe no, maybe you can't put it in Heron. Well, can you put it in Abiquiu? Well, there was a whole bunch of issues dealing with Abiquiu, which ultimately came through. But then there's a question of, well, what do the compact states have to say about it? What does the authorizing legislation of Abiquiu say about the need for the compact states' advice and consent? And so it was complicated, but we were able to achieve the storage of the PMP water, 20,000 acre feet of water in Abiquiu. I don't know if it's still there. Is it still there, Jennifer, or have they moved it?
We're moving it. It might all be moved by now.
Okay, great. And so Jennifer, hi Jennifer, was very, very helpful in preventing the Pueblos from really having to do a lot of arm waving with Texas. So we thank you for that, Jennifer. So that's just one example of some of the recent example of some challenges. So this is, as I said, El Vado Reservoir. It's an older picture of it. I tried to find a picture of it under construction, but I couldn't find one readily. But it's owned by the Bureau of Reclamation, but constructed by the MRGCD. It was, and there was authorization in 1928 to store the Pueblos water there, and for the United States to contribute a portion of the construction costs associated with El Vado related to the Pueblos water rights. And so it was completed in 1935, but then with the rehab in the 50s, when the MRGCD was facing bankruptcy due to the flooding that was occurring, Reclamation came in, and with the rehab, in exchange for that contribution, Reclamation got title to all the MRGCD's irrigation facilities. So the purpose is storing water for irrigation, recreation, also recreational purposes, incidental flood control, sediment control, and then, as I said, storing the Pueblos paramount water rights, which I will talk about a little bit later in the presentation. And there is a storage permit associated with this reservoir, which MRGCD applied for, which now is held by the Bureau of Reclamation. I don't know what happened. It's the wrong button. All right.
Time for questions now?
Yeah. I was going to say, this can be a dialogue. If you all have questions or want to make any comments as I'm going through, please feel free to interrupt me. All right, and so this is a good time to talk about the Middle Rio Grande project. This was authorized by the Flood Control Acts of 1948 and 1950. for the Corps and for the Bureau of Reclamation to make improvements. As I said, BOR rehab Elvado. The Corps constructed flood control reservoirs. That would be Abiquiu, Cochiti. Actually, I don't know if Cochiti was part of that. I think Cochiti was a separate authorization, but certainly the jetty jacks and other things were part of that authorization. It was originally, Elvado, as I said, originally built by the district. Here, this is interesting. This is from Reclamation's website. It says there's 30,000 acres of Pueblo water right lands within the project, which is a little bit higher than the PNP and NRL lands combined. I think that's more like 20,000. So not sure where that number comes from, but I like it, representing the Pueblos. And then also features rehabilitated, which we'll talk about, are the 4 diversion dams. So then we'll move down to Abiquiu, and here's a picture of Abiquiu Dam. It was completed in 1963. It's a core dam. Again, Flood Control Acts of 48 and 50. This really primarily was, in addition to the flood and sediment control, was for storage of San Juan Chalma contractor water. But I do believe in 2020, WRDA authorized storage of Nato Rio Grande water there as well. Significant to this is the fact that, well, it's hard to kind of see it from this picture, but the Water Utility Authority owns the flowage easements around Abiquiu. So if you want to store any water there, yes, Mickey?
Just FYI, Board's updating their water control plan, and we will be analyzing storage of native water early next year.
Oh, that's good to hear.
We've got a scoping letter out right now.
Oh, good. So would that mean that if PMP water needed to be stored there in the future, it wouldn't need consent, advice and consent of the compact commission states?
That would be my assumption, yes.
Very good. Thanks, Mickey. And I'm not sure if there's a state engineer permit associated with this. I imagine there must be. It must be held by the Water Utility Authority.
Yes, the water utility authority will have all permits. And the storage easements.
Right. And so that's very significant. And the Water Utility Authority, I know that there was like a few holdout landowners that they hadn't quite, that hadn't quite agreed to convey easements to.
We don't have 100% easements right now, but we're working on it to get the numbers in. Actually, we have easements up to 6220, and we're working on finalizing the easements between 6220 and 6230 for a few of the holdouts.
Okay. And so then that 6230, that was in the WRDA authorization, is that right?
Yes.
Okay. All right. Good. Well, my research paid off. All right, so here's Otoe Gauge. This is a very significant. Oh, yes, go ahead.
WRDA, so I don't know that one.
Oh, it's the Water Resources Development Act. Is that what it stands for? Yeah. So it's Congress every 4 years or something passes a new WRDA bill.
Every 2 years.
Every 2 years they pass a bill, and so it was in that. Yeah. Apologies, but. It authorizes a lot of different things associated with water, and this is just one little piece of it. The legislation is quite long. So here we have Otoe Gauge. This is important for compact delivery purposes. Who do we have from the state of New Mexico ISC here today? Anybody? Just one person? Where's Chris Shaw? Well, then I guess I can just, you'll just have to correct me on all the things I say about the Rio Grande project. So this is what sort of determines what New Mexico's delivery obligation to Texas is. It rings the bell, as they say. The water that flows past there rings the bell and determines how much New Mexico owes to Texas. And then, of course, Texas really is mostly New Mexico. There's geographic Texas, and then there's compact Texas. Compact Texas is everything below Elephant Butte, which would be all of our hatch chilies and stuff like that. But we'll talk about that a little bit more when I get down to the Rio Grande project. So this is a picture. I think this is looking downstream. We're just upstream of Cochiti here. And then there's Cochiti Dam Reservoir, built on Cochiti Pueblo, Army Corps of Engineers. built it 1973. I get Flood Control Act of 1960, so not 48 and 50. It's flood and sediment control, fish and wildlife, recreation, and irrigation. Irrigation, is that really I don't know. I got this from the website. I don't know if that's right. I don't know. I don't know where I got that from, but I don't know that that's true actually, because it's not conservation story.
There are two main canals that come off of.
Yeah,
That's true. So maybe it's for that.
but like irrigation and, water supply is passed through,
Right.
so we maintain the 1,200-acre surface area with, San Juan Chama water, and everything else is passed through.
Right.
Everywhere flood control house.
Yeah. So this is one of the things that the Wild Earth Guardians was trying to get the Corps to have to do, force them through litigation, and the court actually sided with the Corps and said that the Corps did not have discretion with regard to what is called deviations from the water control manual. Is that what it's, a deviation from standard operations? And so Cochiti is the only main stem reservoir in New Mexico, maybe the only main stem reservoir. Is there any main stem reservoirs north of Cochiti?
Reservoir way up in the headwaters, I think.
Okay.
But essentially, the only main stem Rio Grande. I always wondered about that when people say the only one, and because we visited way up in the headwaters of Rio Grande Reservoir in Colorado, so I think that also counts.
All right. But in New Mexico, it's the northernmost main stem reservoir above, obviously, the critical reach of the Rio Grande. And so if there was flexibility at this reservoir, that would be great, because then you could have immediate downstream benefits rather than having to do the conveyance, moving it from El Vado or Abiquiu down. But it's on Pueblo of Cochiti land, which is very significant. Do we have any tribal or Pueblo members here today? No. So I do know that there was a lot of problems when this was built. There was a lot of seepage underneath. It leaked a lot, and it really caused a lot of damage to Cochiti's lands. I don't know, Mickey, you can speak to that a little bit, but there's been problems, and the Corps has worked very closely with Cochiti to try to rebuild that relationship. Is that right?
The Corps has worked really hard to rebuild the relationship, but Bureau of Reclamation has done most of the work in the fields to provide the drains so that the fields are usable.
Thanks, Mickey. This is great being able to just reach out to people. All the weak spots of my presentation can be firmed up as we go on the fly. So anything that would be done at Cochiti Dam and Reservoir would need the full support of Cochiti Pueblo, which I don't think. I think their standing or their opening position is no, unless you can provide us with sufficient resources to analyze the options, and then we'll look at it. But they're really not interested in any changes to the operation of Cochiti Dam and Reservoir at this point in time. But I will talk about the federal assessment team and the effort to try to settle the Six Pueblos water rights, and that could change. But that's where we are. That's where it is. So here's just some capacity and dam description, really not that relevant so much. All right, so then we're going to hit the different diversion dams. So as Jonathan said, there is the Cochiti heading, which is where the first water is taken out for the district. We'll look at a district map in a second. But then below that is Angostura, and this is where the district also diverts a bunch of water for its various divisions. Probably should have thrown the district map in here, but we'll just have to revisit it. And then here down, this is Isleta Diversion Dam, which also a lot of controversy there, but in 2016, Jennifer Failer was very instrumental in getting that settlement with Isleta done. Here was a bit of a quandary. So as I mentioned, the United States took ownership of all the district facilities when they did the rehab in the 50s, and so they took ownership of Isleta Diversion Dam. Well, MRGCD did not get the full rights to have Isleta Diversion Dam on Isleta land. So the United States, who has a trust obligation as trustee for the Pueblos, was in trespass on the Pueblos' lands, and that was for a long, long time. And Isleta was not happy about that, and so not only that, but there's a lot of sediment problems, which I believe are really caused by the fact that Cochiti is where it is, so it deprives so when the water comes out of Cochiti, it doesn't have any sediment, it picks up whatever sediment's there, and then it sort of dumps it here, which is why you don't have much sediment. It's more gravelly riverbed below Cochiti, but then this is where it ends up, and then it ends up in all of Isleta's canals and stuff. So as part of the settlement, Bureau of Reclamation and MRGCD agreed to fix that, remove all the legacy sediments that was there, and come up with a plan to prevent it from happening again in the future. And there's also going to be a fish passage. I should mention that, I think that's relevant here. There's going to be a fish passage that is being developed. Jennifer, when do we think construction will start on the fish passage?
We're awarding a design-build contract next month, and probably have a year for design, and then start construction in 2024. My voice projects. Awarding a design-build contract in January, probably about a year for design, and we'll start construction on both Isleta and Santa Casia Diversion Dam fish passage in 2024.
Thank you, Jennifer.
Deb Hill will hold us to that.
That one would just be following Catherine's tightrope approach. That you have an eye on the vision, but it's hard to get. You can't get there in one step, and so it's been a lot of years of breaking it down and moving forward in steps to get to where we are today. So yeah, I think that would be a good example of the tightrope approach, where it seemed maybe unachievable at one point, but now we're almost there.
I think it was maybe Mindy Harm Benson. She's at UNM Geography or something, but she had come up with we had used this actually when I was at Reclamation, a way of rating the different things that you could try to do on a river to get for minnow purposes or other purposes, and aligning that or following kind of the rapid classifications. And so if something was like class 6, then you were certain to die. And I guess, so whatever project you were trying to complete would not. And then there are class 5s and class 4s. I don't know, this may be class 4, I don't know. Everything on the Rio Grande is class 4 or 5, I would say. And if any of you are river rafters out there, I don't think I've ever done a class 4 or class 5. But yeah, they're treacherous. So just to give you a sense of the difficulties of accomplishing these things. So here's Santa Casia Diversion Dam with the fish passage that Jennifer was just mentioning. And then here's Elephant Butte Dam and Reservoir. So this is the southernmost in the sort of middle Rio Grande. This, I guess, marks the southern boundary of the middle Rio Grande. And this is also the northern boundary of the Rio Grande project, which supplies 178,000 acres of land. This is from BOR's website, so that's my disclaimer. But 60% of the lands that are in compact Texas are really in New Mexico. 40% are in Texas. So that's, I think, a hard thing to wrap one's head around. Like when you talk to people and they're like, yeah, Texas is just taking all of our water. Well, it's really New Mexico that, mostly New Mexico. So the Bureau of Reclamation constructed it in 1916. Elephant Butte Irrigation District, which is served by this, I think there's one of the oldest projects. I think Elephant Butte Dam is one of the original projects. Yeah, because you see it was authorized in 1905, right after the Reclamation Act of 1902. So for those of you who don't know, 1902 is when Reclamation really was founded or established by Congress. So here the purposes are really conservation supply for irrigation, but also flood control, power generation, and recreation. And then there's a pool here for the city of Albuquerque to store some of its San Juan Chama water. And then there's also Caballo, which is downstream. And not exactly sure. Those are managed together for the Rio Grande project. Oh, and then also, I guess, as part of the Rio Grande project, water is provided for diversion to Mexico by the IBWC, International Boundary and Water Commission. And so I'll just talk just briefly about the treaty in a few slides. All right, so that kind of covers the plumbing. Is there anything I missed that anybody can think of?
Question?
Yes.
What is the status of Jemez Canyon Reservoir at this point?
As far as I know, it's really just sedimented in. It was a Army Corps of Engineers dam, but it's really not in use anymore, as far as I know. Is that right, Mickey?
It's flood and sediment control.
Okay.
But the gate's open, so we're passing. Mickey, correct me if I get this wrong. My understanding, we're allowing sediment to pass through, so the gate's basically open all the time. But if there were a large event and flood control was needed, we could still regulate Jemez Canyon. And then the other dry dam is Galisteo Dam. And so Jemez, Galisteo, and Cochiti are operated together so that the safe channel capacity through Albuquerque is not exceeded.
Thank you. And I do think that Galisteo and Jemez were authorized when Abiquiu was authorized under the 48 and 50 Flood Control Acts. But thanks for that question. I should have included Jemez and Galisteo. All right, so now we'll shift to Pueblo water rights. And I believe the speaker after me is from Isleta Pueblo, and we'll be talking. Oh, yeah, Amador. Hi. So you two will be talking about your irrigation. So that'll be great. I look forward to hearing that. So I think it's important to know that the land between Taos and Socorro along the Rio Grande is the oldest continually settled section of the United States. That is very significant when you come to think about the Pueblo's water rights, because they have diverted water from the Rio Grande since time immemorial and have rights associated with that. And so the Pueblo's rights, I thought it would be useful to maybe talk a little bit about the magnitude of their rights, because they're significant. They have rights to 3 different times, past, present, and future, for all types of purposes. So that would, I listed the ones that I can think of, and the tribes could make arguments for things that aren't up here. Domestic, commercial, municipal, industrial, agricultural, livestock, environmental, and then I did kind of a catch-all: religious, traditional, cultural. But none of the claims have been quantified. I'll also mention that they have rights not just to surface water, but to groundwater. And so none of the claims, the Pueblo's claims, have been quantified. We do have the 1928 Act, which established that certain of the Pueblo's lands are prior and paramount, which means they get seniority. And then others of the lands are, quote unquote, newly reclaimed. To me, this is under the doctrine of Federal Reserve water rights. They can not be lost due to forfeiture or abandonment. So the fact that Congress said, because in 1928, basically what Congress said is the P&P lands, the ones that they identified as prior and paramount, were the ones that were actually being irrigated at that time. The ones that had previously been irrigated but required some reclamation, they called newly reclaimed. And so they gave the newly reclaimed lands a priority date of that with the rest of the district, which I do think is, I think it's wrong. I think all the lands should have been prior and paramount, because the doctrine of Federal Reserve water rights holds that water rights of tribes cannot be lost due to non-use or abandonment. So that's a bit of an anomaly, but that's what Congress did. And what Congress didn't do, they said that there were prior and paramount lands and newly reclaimed lands, but they didn't say how many acre feet were associated with each one of those designations. So the Pueblos have a total of 8,847 acres of P&P lands and 11,951 of the newly reclaimed lands, for the total of 20,000. That's why I pointed out that 30,000 number earlier. There may be things that I'm missing. So in any event, the water rights have not been quantified. And that's part of the challenge here, is that you've got the most senior water users on the system with unquantified water rights. It It really is a cloud over all of the water users' rights. Because if the Pueblo's future use rights, I mean, I know Isleta has a lot of arable land, tens of thousands of acres of arable land. And I think, and the other Pueblos do as well. If you, under the Winters Doctrine, which holds that when Congress reserved land for tribes, they impliedly reserved enough water to meet the needs of the tribes. They follow something called the practicably irrigable acreage standard, which really looks at, well, how many acres could be grown on that land to determine what the future use right is. There's also something called the homeland standard, which looks even beyond that to other sort of commercial developments. But the Pueblos have very large claims to water. And so it's just really, and they can't market their water now, which because we don't know what the quantity is. And Congress, unless Congress says the tribe can market its water, it can't. And so one of the things that comes out of an Indian water rights settlement is the ability for a tribe to market its water. And you see that happening a lot right now on the Colorado River. The Gila River Indian community has something like, I don't know, like 400, 600,000 acre feet of water, and they have been leasing that water to offset some of the impacts of the shortages that the Colorado River users are facing right now. So we have these huge claims, unquantified, and that just complicates, I think, everything. And then, let's see. All right. So, and as I said, the Pueblo's prior and paramount, or water for the Pueblo's prior and paramount lands, are stored each year in El Vado. Right now, they're in Abiquiu, as I said. But they're released at the end of the year. They go downstream. Any water that's not used. So the way that Reclamation and BIA and the state of New Mexico and the MRGCD, everybody kind of has interpreted the Pueblo's PMP storage is that it's really just an insurance to make sure that the Pueblo's rights are met in that, or needs are met in that year. Their water needs are met in that year, but there is no right to carry over that water. At least that's how it's being operated right now. So that is something that the Pueblos have long argued to get some sort of carryover storage of their water rather than having it be released at the end of each year. Okay, so any questions on the Pueblos water rights? We'll talk about it again when we get to the federal assessment team. So let's talk a little bit about New Mexico water law. I think this is an important point, this first point here about the federal government relinquishing authority over water to the states. So that was something that was done in the Desert Lands Act and definitely in the Reclamation Act of 1902. So Congress has said that the states have the authority over the allocation and administration of water, except where Congress has reserved it for other purposes, which would be for tribal rights, national parks, any federal uses of water. And it's important to know that the water rights, they're interest in real property that cannot be taken without just compensation. I'm working on a paper right now that looks at Montana's Reserve Water Rights Commission and how that operates. And so I've been thinking a lot about some of these issues as early as this morning, or as recently as this morning. And one thing that's interesting to note when it comes to compacts is that the state of New Mexico has the ability, because of its authority over water and because of its inherent sovereignty, to tell these private water right owners that they can only use up to whatever the allocation is that they've negotiated with another state, for example, under the Rio Grande Compact. And so there's this great case called the Hinderleiter case, Supreme Court case, where there were some senior Colorado water right users. They were senior to the New Mexico users, and they were trying to make a call across the state line, and the Supreme Court said, no, you can't do that. You are limited by what the state of Colorado has negotiated on behalf of all the water users in the state. And so, that interest in real property that can't be taken without just compensation, there are limits to that because these are, as I said, due to the state's authority. So the code, New Mexico's water code was enacted in 1907, created the state engineer's office, and really what the reason for the enactment was really to capture all the unappropriated water as I'm been doing my research in Montana, it really was the motivation for a lot of states in their water codes was to try to capture as much water as they could in the state and prevent downstream states from having any claim to it. So New Mexico did that in 1907. Of course, we follow the doctrine of prior appropriation, but we don't really operate that way here in New Mexico. So we don't have anybody from the state engineer's office here either? No? Okay, good. Um, Can't check me. And of course, the water rights of the Middle Rio Grande have not been adjudicated. Okay, so here's the MRGCD slide, which I probably should have put earlier. So you can see the different divisions that the MRGCD operates. And so you can see the 4 different diversion dams. So Cochiti and Angostura provide water to the Sandoval County. I don't think they call it the Sandoval County. The Cochiti, yeah, it's the Cochiti division is I guess served by Cochiti Dam and probably part of Angostura. Let's look at this map. You can see actually which of the divisions. So the district is divided up into different divisions. There's the Cochiti Reach, there's the Albuquerque Reach, I think there's the Belen Reach and the Socorro Reach. And the diversion dams take out water to meet the needs of the Pueblos and the non-tribal water right users as well. And so the district is kind of an interesting entity. So do we have anybody from the MRGCD here? Hi. They're a political subdivision of the state. They were formed in the 20s to deal with all the waterlogging that was happening and also to consolidate. There were something like 71 little diversions that Acequias and the Pueblos were using, and the MRGCD, that was all consolidated into these 4 diversion dams. And there was an official plan that was approved in 1925. But under the Conservancy Act, which is where the district formed, they actually have a tremendous amount of authority over their water users. And I don't know that we even know we've not tested the full extent of that authority. Okay, so move on to the Rio Grande Compact, which we've talked about a little bit. It apportions the flows amongst the 3 states. It was interesting because this slide I had taken from a previous presentation, and it said the compact was intended to protect the water uses in place in 1938. I was like, well, not really with regard to the Pueblos. There is a provision that nothing in the compact should be construed as affecting the obligation of the U.S. To the tribes or impairing the rights of the tribes. But that really was like just, I don't know, they just punted on that. And I wouldn't say that it was meant to protect the Pueblos' uses, for sure. New upstream uses were only allowed with imported water, and they assumed that the system was fully appropriated. And it's gauge-based, as I said. Lobatos, I think, is the gauge in Colorado. I think it's in Colorado. And then Otoe is the one that I pointed out. And so, as I said, New Mexico's obligation is based on the amount of water passing the Otoe gauge, as well as the amount of water released from Elephant Butte and the change in storage. So this is from New Mexico's website, ISD's website. There's a credit and debit system. So if New Mexico over-delivers, then they can have a credit for use in future years, which has been really handy because under Article 7 of the compact, if the water in Elephant Butte is below 400,000 acre feet, you can't store water in a post-compact reservoir, which I think would be post-1929, which is El Vado. So you can't, if New Mexico is in a debit status, it can't store water in El Vado. It has to bypass all of that water. So that means that the Pueblos don't get their water, their NRL water also. They get the PP water still gets stored in Article 7 years, but not the newly reclaimed water. However, if this New Mexico has accrued a credit with Texas, then it can store that water even when we're in Article 7 years. I think I got that right. If I didn't, somebody can check me on that. So it's really significant, the credit water. I don't know, I don't think the state has any unallocated credit water left. Do you know if they do?
Unless they move it. it's all been allocated. It's not to say they couldn't continue to move it around, but
Okay.
we all think we know what we have.
Yeah. And so there were some agreements, the emergency drought water agreement that was, gave MRGCD a bunch of water. The state gave the MRGCD a bunch of water and then sold Reclamation a bunch of water so that Reclamation could help meet the needs of the endangered species. That was something that we were always trying to fight against. You know, why should Reclamation have to pay for that water to protect New Mexico's citizens and water users? But it's a federal law, and apparently the Endangered Species Act doesn't apply to the state of New Mexico. Just kidding. That's things. That's some of the stuff that we heard when I was back in the day at Reclamation when we were trying to get the 2016 BO completed. And so, and then going back to the compact, so there's engineer advisors, they meet and they do what they do to figure out what the delivery, what all the accounting is. I think I've already covered this, and I've covered that. And then here's the treaty with Mexico. I really don't know a lot about the treaty. I know it's there, and I thought it was relevant to bring up, but I haven't seen it really come up as a sort of as a major barrier to things that people are trying to get done in the Middle Rio Grande. There we go. So now we'll talk a little bit about the Silvery Minnow litigation. Yeah, so parts 1, 2, and 3. So I think I was there for parts 2. Now we're in part 3. This is part 1. Just a little bit about the fish, which you already know, I'm sure. It was listed in 94, critical habitat in 99, and then that's when the Silvery Minnow lawsuit was first filed. And at that time, I guess the Corps and Reclamation had not consulted yet over their actions, water management actions. And then when they did consult, I didn't cover this in here, but then there was a BA, and the BA was combined for the Corps and for Reclamation and for all the other water users. My understanding it was a depletions-based BA where Reclamation and the Corps really basically said, you know, we're covering everybody. We're not gonna look at everybody's individual actions and the impacts of each entity's actions. We're just going to provide coverage broadly for everybody. Can I get a time check? How am I doing on time? 7 minutes. All right. Okay. So that's what the litigation was about, and there's a lot about what Reclamation's discretion was with regard to San Juan Chama water and with regard to the MRGCD water or native water. And we had rulings of Judge Parker, all of which have been dismissed. But Parker did find that Reclamation had discretion. But then Congress intervened. This would be Senator Domenici, and got us the Minnow Rider. And that Minnow Rider basically took San Juan Chama water off the table. And then in 2005, Parker ruled that Reclamation's discretion was mooted. I'd be happy if anybody wants to talk about Reclamation's discretion over the diversion plans. I'm happy to talk about that with you on the break. That's a rich discussion. And then, so then in 2010 is when the 10th Circuit overruled all of Parker's decisions as moot. So then we get to part 2, and this is where, this is when I was at Reclamation. We were working on the biological assessment, and our goal was, it was all about action by action. We were going to shift the burden from Reclamation, who are having to spend tens of millions of dollars every year of federal taxpayer dollars, and trying to get the MRGCD to step up more, really, and the state of New Mexico and all other water users to try to provide water in the river. Part of this is because Reclamation's, the way Reclamation was providing water was through San Juan Chama project water. And so this would be unallocated or unused San Juan Chama water. But that has passed, and all the water users are now really using their full allocations. And so Reclamation knew that supply was going down. And so that's part of what the incentive was, to try to do this action by action, where we looked at each individual action, all the diversions, the storage of each entity, to try to figure out who had what obligation. And then the idea was we were going to match their mitigation, conservation measures to make sure that they were offsetting the impacts of their actions. didn't really work out quite like that, but that was the intention. And so we did, so you can see BOR in 2015 submitted the action by action BA, got the BO in 2016. I guess I missed that WEG filed suit in 2014 against the Corps. Oh, and then the Corps was very, very slick. This was Beth, I think.
As Beth and William.
Beth and William, and yeah,
Because the service would not issue or accept a separate consultation, and then for the Corps, then we got direction from headquarters to reevaluate everything. So Beth and William sat down for 6 months and went line by line on our authorities and came to the conclusion that we had no discretion at Cochiti to deviate from our water control plan. And that was summarized in a memo signed by who is now General Grant. We sent the memo over to the Fish and Wildlife Service and said, we had two small items of discretion. One was at Abiquiu, I think the other one was maybe at Jemez, and then said, we have no discretion at Cochiti. And that caused a lot of angst with the Fish and Wildlife Service and, of course, Wild Earth Guardians. And as you note there, the court agreed with our assessment. We have no discretion. It is unique within the Corps of Engineers that Cochiti has no discretion, is the one dam that has no discretion on how they operate. And that's because Texas did not trust the Corps and the state of New Mexico. And on a sideline, that probably has been one of the benefits for the silvery minnows. We have no discretion at Cochiti.
so that's, I think, just thinking about the jurisdiction and authorities and, how that really changed. That was a big shift over like 10 or 15 years from, originally the Corps and Reclamation were in the BA together. They got a joint BO. There was all kinds of obligations, RPAs, RPMs. And then we go to the new process, and the Corps like, we're not going to hang with you, Reclamation. You guys, we're going to give us, yeah.
We were simply wrong. Never have consulted.
Right. And so you were smart. You saw that you really didn't have a lot, the Corps didn't have a lot to contribute or a lot of liability because you didn't have a lot of discretion. And so that's what, when you think about liability under the Endangered Species Act and all the Supreme Court cases, it all comes down to agency discretion. Does an agency have discretion to do these things, or did Congress say you must do this? Because if Congress said, okay, you must do this, then there's no discretion, then that overrules the Endangered Species Act. And you have two congressional or statutes that are competing with each other. So anyways, I'll move on. Now we have this new lawsuit, which you all, I'm sure, have read or are familiar with. So we'll see what happens. So this is just some climate change stuff. I mean, I think the key thing here is getting warmer and drier. Temperatures are going to get up by, this is under the state's Leap Ahead report, 6 degrees in 50 years and 25% less water in the river, in the Rio Grande, which is, so then you take this, we're already in a bad place. It's going to be less, and then you have all these tribal rights that are unquantified. You guys have your work cut out for you here. But let's see. But here's some hope. I think this is very hopeful. So my last few years at the Department of Interior, I worked on the Indian water rights settlements throughout the West. And so one of the things that I always wanted to see happen was a federal assessment team to New Mexico to help resolve the Pueblo's water claims. And this year, the Department of Interior appointed a team. And so it's going to take a long time. But right now they're in the assessment mode to try to determine, is a settlement feasible, possible? And if so, then we'll hopefully move into negotiation and eventually get to a settlement agreement, which would quantify all the Pueblo's claims and bring a whole lot of federal money and reauthorization of reservoirs possibly with it. There's a ton that can be done with the federal assessment team. That's why I ended on this slide, because I do think that this is kind of hope. here, but it's going to take a long time. And then that's it. That's John Wesley Powell's map. If only it'd be a whole lot easier. And then that's it. That's my closing thought. So thank you all, and I got it done in time.
Stay up there, Josh. We're going to do Q&A. Josh, stay up there. Josh, stay up there. All right, so we have 15 minutes for Q&A, a little less than 15. Anyone questions? Did you get all your questions in during the presentation?
Okay.
All right. I propose a break. Jim's got one. Okay.
All right, well, yeah, since no one else chimed in, we can't talk about the current litigation, but go into a little bit more detail on that, if you could, on that one thing on the diversion rights that you said folks could talk about you at the break or lunch.
Sure.
With a few minutes, could you delve into that a little bit more?
Yeah, okay, I gotta plumb my memory here a little bit. Yes, but as I said, so discretion is really the key to what the courts are looking at, and whether or not the Bureau of Reclamation has discretion over the diversion dams, because Reclamation, as I said, owns these diversion dams. So Wild Earth Guardian's position is, well, if the United States owns the diversion dams and the minnow is dying in the river, can't Reclamation use its federal authority to just keep the water in the river and not divert it for the farmers? So that really is the discretion question, and that's what Judge Parker really said, that Reclamation did have that authority. And so, but there's reasons why there are limitations, and that goes to the state water rights. And so Reclamation cannot, and so this is just, I think, an interesting legal question, is the degree to which that Reclamation could try to deprive or curtail state-based water right owners of their rights to meet the needs of the minnow. And that's certainly, it's an issue that nobody really wants to have to confront. But we did look at that a lot when I was at Interior, because we really admired what the court was able to do. We were like, well, how can we figure this out? Reclamation has no discretion, right? And so there's actually a case. So the MRGCD has two permits. One is 1690, and that's for the storage at Elvado. That's Reclamation holds that. The other one is 620. Reclamation does not hold that, and that is for the diversion of water. So there's actually a New Mexico Supreme Court case that where people had objected to MRGCD conveying permit 620 to the feds, because they didn't want the feds to be able to just willy-nilly deprive them of their water. And so the Supreme Court of New Mexico agreed, and so that's why the MRGCD only conveyed permit 1690. And so based on that, it's like, well, Reclamation doesn't have any discretion either, because we can't deprive these, we don't hold the permit. We have to comply with state law, right? As I said, the feds have relinquished the authority over appropriation and administration of water to the states. So if the state Supreme Court has said that we can't do it, we don't have the permit. So just because Reclamation owns the diversion dams doesn't mean that Reclamation can just not divert water. But that really is the key question. And then the other thing that I'll mention is there's also the Pueblo question. And so I don't know if you saw in the litigation, the lawsuit, but there's a footnote that says, we're not challenging the Pueblo's use of water, basically, is what Wild Earth Guardians put in there. And they're being very savvy, I think, because I don't think that's would sell to their constituency that we're gonna take water from Indian tribes. And so they are trying to walk the line of saying, yes, Reclamation, you need to do more. MRGCD, State of New Mexico, you guys need to do more. But really what happens is at certain times of the year when there's no water, the only water in the river is the P&P water. And so that's maybe when the minnow might need some water. But so then there's always the potential of a showdown between the Pueblo's P&P water rights and the needs for the Endangered Species Act. And that is something that I think nobody has any interest in trying to to have a court litigate that. At least they haven't up until this point. So hopefully that will remain to be true. So, thanks, Jim.
Any other questions?
You referred to MRGCD's authority having not been fully tested. Can you elaborate on that point?
I don't actually know a lot about this, but from what I understand, conversations that I've had with some folks with the state of New Mexico, the Conservancy Act actually gives the state, gives the MRGCD maybe the authority that while the Guardians hoped that the reclamation would have over the diversions. And I think, arguably the MRGCD could make a lot of decisions with regards to what it would do to meet various needs and deprive their water right users of things. I think the MRGCD arguably has a lot of authority. Of course, they wouldn't ever exercise it in that way because everybody would get booted off of, the board, and the attorney would be fired, and so would the Jason Kasuga. But arguably, they have such authority under the Conservancy Act.
If there's no more questions, thank you, Josh.
Yeah.